How to protect your kids' inheritance from a divorce. If your kids go through a divorce, part or all of their inheritance could be on the line because it could get split up in the divorce settlement. We're going to talk about how to protect your kids' inheritance from any divorces that they may experience in the future. Most parents assume that you're leaving the inheritance to your kids and that inheritance will be protected from any future divorces that they may experience. But that's not true because most kids are just going to deposit that inheritance into a joint bank account or retitle that property to be jointly owned with their spouse, which means that their inheritance could get split 50-50 in a divorce settlement, whether it's money or property that you're leaving behind to them. One of the easiest ways to set up asset protection for your kids' inheritance is using a trust. Instead of passing it down to them in their personal name, you leave it inside of that trust. That means that your kids still get to use it, whether it's for healthcare reasons, education, their home, a business, etc., and that their spouse can't touch it because it's a legally separate property, and then the divorce settlement can't touch it because the trust owns it. Your child does not own that property. But just because you leave it inside the trust does not mean it has asset protection from your kids. You have to set up correctly. So let's talk about some of the clauses that you want to include inside of that trust. The first one's going to be a spendthrift clause. This keeps your kids from using the money or the assets inside of that trust as collateral for any reason, and it protects it from creditors and their spouse. Basically, it means that your kid cannot give those assets away and no one can take it by force. This one's super important, which is distributions at the trustee's discretion. Instead of giving your kids full control over their inheritance or giving them regular distributions, what you're doing is allowing the trustee to decide when those distributions should happen. This makes it super clear in a divorce settlement that those assets are not being used at the child's discretion and they're not getting regular distributions or assets that the divorce settlement could garnish or split up. You also want to make sure that the trust clearly states that all the property inside of the trust is clearly separate property and not marital property. And make sure you do not put any language in there requiring distribution. So an example will be annual distributions out to your kids, because those distributions at a regular interval could be garnished for that divorce settlement and they could be split with the ex-spouse. So who should be the trustee of this and have control over the assets inside that trust? You have three main options. One could be your child. It's easy, but it's a little bit riskier in court. The next one could be a family member, but it needs to be someone that you can trust to manage the assets inside of that trust. Or it could be a professional trustee like an attorney, which will give you the most protection and be the most reliable. Most families are just going to choose someone inside of their family to be the trustee of the assets inside their trust. Can't you just pass that inheritance down to your kids and tell them to keep that property separate from their spouse? You can, but it's risky. So what's going to happen is the courts could decide that you have commingled those assets. The reason being is that your kids could accidentally deposit that money into a joint account, which makes it marital property. They could also transfer money from a joint account into the account for their inheritance, which will also commingle that money. And then for property, they might accidentally retitle that property to be jointly owned with their spouse, or use marital money to upkeep or take care of that property, which makes it marital property, even though it's only in your child's name. And so if you are going to go this route, it's super risky. It's a very high likelihood that it becomes marital property and that it will be split up in the divorce settlement, but it is possible to pass the inheritance down to your kids and then keep it fully separated from their spouse. So when should you set all this up? Now is obviously the best time, because if you don't put the assets inside of a trust and you pass away with those assets in your personal name, they will have to go through the probate process and get split up either per the instructions inside of your will or per the intestate laws of your state. And then those assets are going to go down into your child's name. Therefore, they're going to become marital property and subject to being split in a divorce settlement. Other benefits of this setup is not only protection from a divorce settlement, these assets will also be protected from any lawsuits or creditors coming after your kids. Those assets will not be accessible to those liabilities for them. So what you can do is set up a revocable trust, put all of your assets inside the revocable trust, name your kids as the beneficiaries, and then when you pass away, you do not distribute those assets directly out to your kids. You keep them inside that revocable trust to be managed by the trustee, and then that way those assets will have asset protection from any of your kids' divorce settlements. If you want help setting any of this up, click link in the bio, fill out the form, and schedule a time to talk to someone on our team.